house. This is the United States private enterprise free state in on the check on. And what we will be discussing today is executorship and naturalization with the laws for your remedy. Gather in right, my people. This is a broadcast. This is a public announcement broadcast. So check it, my people. For the latecomers, nobody's too late to become the executor of their estate. Well, we're going to start off with the Naturalization Act. How does that sound? The Naturalization Act. That is what we're going to start off with this executorship, is the Naturalization Act. So, my people, the Naturalization Act refers to a series of U.S. laws that establish how a non-citizen can become a U.S. citizen. Okay? That is very important to know, my people. Why is it important to know? Why? You ask why. Well, U.S. Naturalization Acts. 1. Naturalization Act of 1790. First, U.S. naturalization law limited citizenship to free white persons. Required 2 years of U.S. residence. Excluded Native Americans, enslaved people, and others. Naturalization Act of 1795 replaced the 1790 Act, required 5 years U.S. residency, declaration of intent, first papers, oath to support the Constitution. Naturalization Act of 1798, part of the Alien Sedition Acts, increased residency requirements to 14 years, highly controversial, later replaced. Naturalization Act of 1802, reduced residency back to 5 years, formalized court procedures, clarified requirements under federal authority. Naturalization Act of 1906, major reform, standardized naturalization nationwide, created federal oversight, precursor to USCIS, required English language ability, required documentation and records. Immigration and Nationality Act of 1952, INA, McCarran, McCarran, Walter Act. Still foundational law today. Ended racial restrictions on naturalization, organized all immigration and citizenship laws, introduced ideological exclusions, later softened. Current naturalization today, governed by the Immigration and Nationality Act, INA. Lawful permanent resident green card, usually 5 years residency, 3 if married to a U.S. citizen. English and civics test, oath of allegiance. If you want, tell me this, my people. How does Naturalization Act tie and connect in with executorship? Okay? We are going into historical and constitutional private status versus citizen, race-based classifications, modern USCIS process, and specific year or statute. Okay? So basically, controlling law, naturalization, primary authority, U.S. Constitution. Article 1, Clause 4, Congress has power to establish a uniform rule of naturalization. Governing status. Current. Immigration and Nationality Act, INA, 8 USC. The key sections that we want: 7, general requirements, residency, good moral character; 8 USC 1446, examination, procedure; 8 USC 1447, judicial review and remedies; 8 USC 1451, revocation, denaturalization. How does this tie into your executorship? That's what this boils down to, my people. And that's why you're tuning in right now. So, once a person meets statutory requirements, naturalization is not discretionary. The government has ministerial duty to act. Courts have repeatedly held USCIS cannot delay indefinitely. Failure to act triggers judicial remedies. Remedies, my people. You see what I'm saying? The remedies, when you become the executor over your estate, and now you are triggering the naturalization laws for the executor, because you're going to have to fight for this. Remedies provided by law. Judicial review for delay. 8 USC 1447B. If USCIS fails to decide within 120 days after the interview, applicant may file in U.S. District Court. Court may decide the application itself or order USCIS to act by a deadline. This is a statutory remedy, not discretionary. Mandamus, compel performance. 28 USC 1361. Used when a government officer has a clear legal duty. Applicant has a clear legal right. No other adequate remedy exists. Remedy: court orders USCIS or DHS to perform the required act. You're the executor. You have been nationalized into a foreign system, United States. You are already a Native American. Administrative Procedure Act, APA, 5 USC 555.706. Remedies include compelling agency action unlawfully withheld, setting aside actions that are arbitrary, capricious, contrary to law. This applies to delays, improper denials, failure to follow statute or regulation. De novo review of denial. 8 USC 1421. If naturalization is denied, applicant may seek de novo review in federal court. Judge reviews facts and laws independently. USCIS gets no deference, DEFERENC. This is a powerful remedy. Declaration and injunctive relief. 28 USC 2201-2202. Used to, my people, sorry about that interruption. But this is the declaratory and injunctive relief, which is 28 USC 2201-2202, used to declare legal status or rights, enjoy unlawful government conduct. Okay, my people, keep tuning in, because we are just at a tip of this, okay? Historical remedy context. Under Early Naturalization Act 1790 to 1802, courts had exclusive jurisdiction. Naturalization was judicial act, not administrative. Remedy for refusal can be direct court petition. Martin law preserves this concept through de novo review, mandamus, statutory deadlines. Important legal principle. Naturalization is a right once statutory conditions are met, not a privilege. Government agencies cannot invent requirements, cannot delay indefinitely, cannot deny without lawful cause. What this means practically, my people, okay? What does it mean practically, my people? What does it mean? Okay? Um, this means practically, okay? I'm going to tell you. A person may lawfully force a decision, bypass USCIS delay, bring the matter directly before an Article 3 court, obtain relief even without agency approval. Now, my people, you may have to draft your mandamus 1447 filing. You can do a layout or a step-by-step remedy strategy. And this is dealing with your naturalization because this is dealing with your birth certificate from day one. The birth certificate has renaturalized you into the United States from the contracts that you have signed throughout your whole life. So you were born on your birth certificate into the state. It says it right on your birth certificate. The state of California, the state of New York, the state of Mississippi, whatever state you will come from. So now, two separate jurisdictions. These key points: naturalization, public law, federal jurisdiction, governed by U.S. Constitution, Article 4, Clause 4, Immigration and Nationality Act, 8 U.S.C. So basically, you're going to have to look up all those laws under 8 U.S.C. dealing with naturalization and using those naturalization laws as an executor when claiming your estate if you get pushback. That's the whole thing, my people. Now, executorship of an estate, probate, trust law, state jurisdiction, governed by state probate courts, trust instruments, letters testamentary, letters of administration. So, no estate, living, decedent, private or express, can confer, settle, discharge, or substitute for naturalization or citizenship. Okay, they do not merge. So basically, executorship of an estate it doesn't really merge with naturalization. But there's things in here that you may have to see. So executorship actually connects legitimately. Executorship only connects to naturalization in procedural capacity, not status creation. Executorship only connects to naturalization in procedural capacity, not status creation. Executor as legal representative. An executor may act for an estate when a decedent had a pending immigration or naturalization matter. There are fees paid, property rights affected, refunds or claims owed. So, decedent filed Form N-400 and paid fees. Died before adjudication. Executor may notify USCIS, seek fee refund, close administrative matters. But only the executor of the estate can do that. That is why you have to become the executor of your estate. I'm only giving you something dealing with naturalization. Now, an executor cannot complete naturalization for the decedent. Citizenship does not vest post-death. Evidence and records. An executor may lawfully obtain certified records, authenticate documents, provide proof of identity, residence, or status for estate's matter. But this is evidentiary, not jurisdictionally authority. jurisdictional authority. So your court standing is very narrow. Executor may have standing to protect estate interests affected by federal action, challenge unlawful withholding of property or refunds. Executor does not have standing to assert citizenship, assert national status, assert political rights on behalf of the estate. The executor cannot do any of that. So this is pertaining to executorship and naturalization, confers sovereign or diplomatic status pertaining to naturalization. So any claim that citizenship flows from an estate, the executor controls political status or naturalization is settled through a state and will fail in court. So basically, what I just said, you cannot do that as an executor over the estate pertaining to naturalization. So, the confusion exists historically, and we're here to give you clarification on it. Early naturalization from 1790 to 1802, naturalization occurred in court. Judges acted in judicial capacity. This sometimes gets misread as probate authority, estate authority. That is incorrect. Okay? Martin law is explicit, my people. 8 USC 1427 requires personal residence be delegated, cannot be substituted. So in practical, summary, basically naturalization status is an issue, but an executor has no authority over naturalization status. An executor has no authority over the naturalization status oath of allegiance. But the executor does have authority over estate refunds, fees. The has authority over records and notices. The executor has authority over the standing in probate dealing with naturalization records and notices, estate refunds and fees, standing in immigration court. So, no, the executor does not have standing in immigration court as an issue, except limited administrative matters. So, you would have to check the record before you do anything dealing with naturalization and immigration if you're the executor of an estate. So the only real connection, my people, the executorship governs property. Naturalization governs political membership. So you see the difference. Executorship governs property and obligations, and naturalization governs political membership. They operate in different legal universes. So, you're going to have to map out your trust. You're going to have to look at the executor role of what the executor can lawfully do dealing with naturalization. You're going to have to identify where courts draw the jurisdiction line. You're going to have to review your specific claim and your document that connects what you're doing. See how it connects the two, executorship and naturalization. You're going to have to explain how to protect yourself from the invalid filings and sanctions. And that's dealing with the Enemy of the State Act, because the Enemy of the State Act has made all of us people enemies of the state. And enemies of the state have sanctions over the estates. Okay, so, it's a lot that goes along with this once you become the executor of your estate. So, the executor of the state is really nothing to be played around with, my people. You really have to understand the laws that govern executor and then the laws that govern naturalization. So, if you want to get down with this class on the how to become the executor over your estate, 407 300 5377. It's a $50 class. It comes with templates and all the laws that you're going to need because you're going to be spending money just to become the executor of your estate. That's why I, the United States Private Enterprise Free State, own of your estate. You have to learn how to self-govern yourself. And yes, the trust is a state within itself, but you have to know what you're doing. That's why you need to get yourself into this class because this class is major, okay? My people, when it comes to executorship, that's where it's at. You have to be the executor because if you're not the executor, then there's somebody else the executor over you. You know what I'm saying? So, the 1777 Constitution was the first constitution adopted for the state of New York after breaking from the British colonial rule. Okay? So you would have to look up your state and your state constitution because within your state's constitution, you're going to find everything that you need to understand about executorship also. Straight or call us up 407 300 5377. Now, if you want me to drop the class on you right now, you need to cash at me $ RUBIEWILKIE, and that's on Cash App. You want me to drop the class right now? I can do that. Let me get some Cash Apps of $50 right now, and I'll drop you the whole class on executorship. So the Cash App is $ capital R, lowercase UBIE, capital W, lowercase ILKIE. So it's $ RUBIE WILKIE. And that's the Cash App, my people. If you want to Cash App me that $50, I'll drop this class on you right now. What's up? Peace to all my people out there. Everything is good, my people, is good. So, y'all are going to need to really get into what y'all got to get into if y'all really, even as your bonds, paying the debts, because that's what the executor does, and that's one of the, what they tried to keep from you, straight up, you can't, you really cannot register your trust in DMV. That's a no-no for anybody. As an executor, you should know that. Executors only deal with assets in your individual name, bank accounts without beneficiaries, real estate not placed into the trust, wages or refunds owed to your name. If all your assets are titled in your trust, then you do not need an executor over you if you're just a trustee. So your successor trustee handles everything. Yes, if you have a successor trustee. But you want to be the executor. The executor is what you really need to be, my people. Call 407 300 5377. We can get you on that path to executorship. Naturalization is a big thing. So naturalization is something that you want to look into because you need to protect yourself For real. So, my people, what's up out there? How y'all doing? Get at me if you want to get at me, because we about to take this to the next level. We got too many people, but you know, it's stuff that you need to know. The laws on this, So basically, your 8 USC 1401 to 1409 that governs citizenship at birth applies only by place of birth and parentage. Cannot be created by a state trust or executor action, because that shit is created by the state and the registrar. That's who owns your ass unless you come in as the executor. Those are the ones executing your fucking estate and administering it. And question of jurisdiction, which is 28 USC 1331, allows federal courts to hear cases arising under the Constitution, federal statutes, including INA. Executors sometimes rely on this procedurally, not substantively. We talked about the mandamus of jurisdiction, 28 USC 1361, power to compel federal perform non-discretionary duties, often paired with naturalization delays, record correction. Executor may invoke this only for state interests. So you got your estate, trust, and representative authority, state federal interface. That's the probate codes, state law. So, you got the New York SCPA, Florida Probate Code, Uniform Probate Code, UPC, and it controls authority of executors, letters of testamentary, estate administration. And it has no authority over political status, citizenship, or nationality. Now, you can get into your trust law and your Uniform Trust Code, UTC, state trust statutes, and that controls property, fiduciary duties, beneficial interests. But it does not, a trust is not a legal person for citizenship purposes. A trust is not a trust is not a legal person for citizenship purposes. Now you have the federal fiduciary law, which is 26 USC 6012B, and then it's also 31 USC 3713, federal priority statute. Executors must file tax returns and pay federal debts before distributions. So you have to pay everything that the estate owes, the trust owes, before you can distribute any money out to the beneficiaries. This is often misread as federal status control. It is not. Now you have a civil status, a political status, which is critical distinction. Civil status law includes contracts, property, family law, probate. Executors operate here only. So executors are dealing with the contracts, the property, the family law, and the probate. Family court, that's probate court. Political status law includes citizenship, nationality, voting, allegiance, military obligation. Only affected by Constitution, federal statute, personal acts, birth, oath, and residence. So you got records, identities, legal persons, often confused. So vital records law, birth certificates, death certificates. That's all vital records does. They deal with birth certificates and death certificates. Okay. Now the registrar records all of this. So the registrar gets a cut in your labor. Everything the registrar gets a cut in. Believe that shit. Until you come in as the executor and rebut all of that shit. You have to rebut it. The legal, your personhood, which is natural persons, artificial persons, corporations, estates. So legal personhood is a natural person, an artificial person, corporations, and estates. An estate is a legal entity, but never a citizen or national. An estate is a legal entity, people, but never a citizen or a national. It's an ens legis. Okay, so your remedy procedural laws, not status creating. So Administrative Act, Procedure Act, 5 USC 701-706. Review unlawful agency action, delay remedies, no power to create status. The Declaratory Judgment Act, 28 USC 2201-2202. Courts may declare rights, cannot invent jurisdiction or status. Due Process Clause, 5th and 14th Amendments, protects against deprivation of life, liberty, property. Citizenship is liberty interests, but still must be statutorily met. Now, laws that are commonly misused, but this is important. These do not create citizenship or national status. UCC commercial law, trust indentures, private contracts, estate ledgers, declarations of political status, common law filings without statutory basis. Courts uniformly reject these when used to assert status. So basically, laws that are commonly misused is a UCC commercial law, because they do not create citizenship or national status. Filings without statutory basis. So basically, people, executorship is equaling your property authority. Naturalization is going to equal your political membership. No statute allows one to substitute for the other. They may interact procedurally, but never substantively. Now, you're going to have to map out the exact statutes that you need. Why courts may dismiss estate-based status claims, so you may have to look that up to see how you're making your claim for your estate. And you're going to have to see which filings that you can use, versus your sanction risk. And you have to see how it connects to your specific executor or trust role. So it's a lot that you may have to do. So the executor class, my people, is $50. What I'm reading to you and discussing with you right now is just naturalization dealing with executorship, the things that you can and cannot do of the estate. And the only way to take control of the estate is to be the executor. And you have to know what to do. Call 407-300-5377. We can get you heated, started, jumping, get you up to the window, get your paperwork processed and filed. So let's get this popping, my people. 407-300-5377. And we are out.